Ani Bajou. I'd like to welcome the audience to our presentation today on education law with our distinguished guest speakers, Jacquelyn Babinski and Elizabeth McCree. Education law is the legal discipline covering all issues pertaining to schools from kindergarten through higher education. Historically, attorneys practicing education law have worked toward expanding access to a high quality education for all children, as well as providing for greater access to higher education. Elizabeth McCree was born and raised in Benton Harbor, Michigan. She worked as a special education teacher while she attended law school. She's practiced law since 2008 and opened her own firm in 2015. As part of her practice, she handles education matters as part of her work as a lawyer guardian ad litem for children in foster care and for children and adults with disabilities and guardianship proceedings. She also represents special education appeals, initiation of special education services, and re-evaluation of services and disciplinary proceedings, including suspensions and expulsion. She's a board member of the Children's Law section of the State Bar of Michigan, where she sits on the Education Subcommittee. She is also a member of the Bar for the Pokagon Band of Potawatomi Indians, where she takes tribal court appoints on child protection and criminal law matters. Jacquelyn Babinski graduated from Central Michigan University with a BS in Child Development and Psychology in December 2014. After graduating, she spent a year and a half working as a juvenile probation officer for Montcalm County before attending law school. In December 2018, she graduated magna cum laude from Michigan State University College of Law and opened her private practice in Flint in July 2020, practicing education and criminal law. In February 2021, Jacquelyn, along with some colleagues, created MIE AECRES, a nonprofit dedicated to providing education advocacy and legal representation to families in West Michigan. Jacquelyn serves as the executive director and lead attorney and continues to practice education law. Welcome, ladies, and we're greatly honored to be a part of your presentation today. Take it away.
Thank you for inviting us.
Yeah, thank you. And I will go ahead and share our PowerPoint. Okay. So we're here today to talk about education law. We are going to give a brief overview of special education law. It will be very brief, but we will do our best to make the slides available. Hank, will you be able to help distribute the slides to attendees?
Oh, yes.
Okay. So you'll definitely be able to refer back to the materials because it is a lot to cover. So we'll go over special education law. We'll also talk about the intersections of special education law with other areas of juvenile law, including some examples, and then we'll leave some time at the end for questions. But if you have questions in between, please feel free to ask as we go along. So jumping right in, the typical laws that we help enforce, there's four main ones. There's the Individuals with Disabilities Education Act. This is the federal law that states children ages 3 to 21 with a disability require special education and related services thereof are entitled to receive a free and appropriate public education, otherwise referred to as FAPE, based on their unique circumstances, and they need to have the opportunity to meet appropriately ambitious goals. And the IDEA and its implementing regulations further define what FAPE is and what the different processes and responsibilities schools have to follow. And then there's the Michigan Administrative Rules of Special Education, otherwise known as MARS. And the MARS rules give further clarification at the state level to IDEA's mandates, and they implement Michigan's special education laws, which again implement the federal rules. And here in Michigan, one thing to note is that MARS expands on eligibility for services to serve children from birth to age 26. And then we will also look at Section 504 of the Rehabilitation Act and the American with Disabilities Act. Both of those acts are primarily anti-discrimination statutes. So what's nice about those is they typically apply not only to public schools, but also to public agencies or agencies receiving federal funds. And then 504 is also prohibits retaliation. Liz, do you have anything else to add on those?
Only things that I'll add is if you've heard the 504 number before and you have a child who has a 504 plan or something that's been discussed before, that is where that comes from. These are federal acts as well as the Michigan Act, and all schools are required to follow these acts if they want to continue getting funding. That can even include private schools. If they get any type of federal funding, then they're supposed to follow these as well. I will also add that a lot of the work I do also sometimes falls under Title IX when you're dealing with issues with kids where there's allegations that involve inappropriate conduct between students and different things of that nature. So sometimes that also deals with some of the things that we're looking at in education law, depending on the situation.
All right, so the first thing to look at is if you think your child needs an IEP, what do I do? And an IEP is called an individualized education plan, and that comes from IDEA, and it's a plan that specifies what services your child is going to receive, what accommodations, what present level they're functioning at, both academically and functionally, so behavior, social emotional stuff, and then vocational skills, what are their adaptive skills for daily living. And it also specifies what their annual goals are. What do we expect this child to achieve within the next year? And so what is considered a disability under IDEA in order to get one of those IEPs? To be eligible, the child must be evaluated, and one, they have to fit into one of 13 specific categories that I'll go through on the next slide. And two, they have to need special education and related services because of their disabilities. And in Michigan, children are eligible for services again from birth until age 26. I need to fix that typo again. But it's age 26. I'll fix that before the slides go out. And how does a child get evaluated for special education? The child's educational decision maker must make a written request for an evaluation and provide their consent to evaluate, or the district must request and receive parent consent to evaluate the student. That latter part is what we call child's mind. The school district does have a burden where if they suspect a student to have a disability, they should be requesting parent consent to evaluate the child for services. But if the school has not made that request, and in my experience, they usually do not, then the parent just has to put it in writing that they want their child evaluated. All right.
Can I add on to that? I know some people say birth until 25, our kid doesn't go to school until they're 4 or 5 years old. What does that mean? But if any of you have had any experience with the early on program in the state of Michigan, that is definitely an example of services that fall under the federal IEP guidelines, and that's from age birth until age 3. And then at age 3, they can transition into other programs through the school district. And I know that actually some of the tribes themselves have early on programs that they run through the tribe. So that's something to look into. But early on is really sponsored and funded by the same thing that funds the IEPs and provides for that through the school district.
And also too, one caveat I should make on the birth until age 26, it's either age 26 or until the child receives a high school diploma under the Michigan Merit Curriculum. So if your child graduates at 18 with an actual, high school diploma, then their eligibility for services under IDEA would end. But you would look at, what adult services are, available. And these are the 13 categories of disability. You have cognitive impairment, emotional impairment, deaf or hard of hearing, visual impairment, physical impairment, other health impairment, speech and language impairment, early childhood developmental delay, specific learning disability, severe multiple impairment, autism spectrum disorder, traumatic brain injury, and deaf blindness determination. So these are the 13. A couple important things to note is other health impairment, that is essentially any acute or chronic impairment that is negatively impacting the child's ability to function in class. I believe it looks at their kind of their stamina, and I forget the other phrase off the top of my head. Liz, maybe you know, but
The one big thing, at least when I was teaching, with ADHD and ADD, they would automatically be an OHI, other health impairment, as their qualification. That's not always the case now, but they considered that to be a significant enough diagnosis back then that it was always considered OHI. So it really kind of depends now on how the doctors and other people who may be involved classify the diagnosis once a student gets it. But if it's fairly significant, then OHI is really where you want to look at, because that's going to give you more availability to different services targeted towards that. I do also want to touch on the emotional impairment. That is wide variety, and it's really important to address that, because a lot of times we have students who may cognitively do well, but it's the emotional issues that they've been diagnosed with or that they're exhibiting that prevent them from getting the full benefit of their education. I've had students on IEPs for significant depression, eating disorders. It kind of runs the gamut. If a child has an eating disorder and they're not able to eat in the lunchroom, even there's 504 plans that can say, okay, they can eat in a teacher's room or something of that nature to make sure that they're eating, or special diet or different things of that nature to address those concerns. So there's a lot of different things that an IEP can do to address some issues that may not affect kids who they don't have a cognitive issue, but they have an emotional issue that is preventing them from getting the full benefit of their education.
And also important to note too with these categories is, as long as the child is fitting into one of them for services, that the school is then required to address all of the child's related disability needs. So even if your kiddo is is eligible under a specific learning disability, but they also have some behavior and social emotional issues related to some depression, anxiety, ADHD, or whatnot, the school still has to address those issues. They can't just say, oh, it's learning disability, we just get to, wash our hands of it. That doesn't work. Same with if they're, eligible under emotional impairment, but you're seeing them struggle in reading, math, writing, all those academics, the school has to also address the academics.
Yeah, and you have to push for that in Michigan, because Michigan does not like to do more than one classification. When I was in Georgia, we did, main classification and sub-classification all the time. But for some reason, Michigan just doesn't like that. So if you have a child who is, has deafness, but then they also have a cognitive impairment, it's important that you try to get them to push to, label one of those as the major issue. So if they're significantly deaf, that may be the top one. But if they also have, mild learning disability as well, then make sure you put that SLD as a secondary so that you can make sure you're getting all the services and push the school to get them to add that.
Yeah, really making sure it's documented in the IEP what all their areas of needs are, regardless of what that primary eligibility category is. If they have a need, the need needs to be addressed. Because like Liz says, it's weird how Michigan hates doing the secondary and even tertiary. I've seen one school district be willing to list out 3, but it's one in, a few years. So you give your consent to evaluate a child for an IEP. What happens next? After you sign your consent for an evaluation, the school district has 30 school days to complete that evaluation and have an IEP team meeting. Private schools do not have these same obligations. They're not entitled to the same services. Private schools generally, like Liz said earlier, would qualify or be required to follow 504 if they're receiving federal funds. But with private schools, they don't have to follow IDEA. Charter schools are generally, and same with ISDs, are generally publicly funded. They are public schools, so charter schools would need to comply with these same timelines and, evaluation requirements, IEP requirements, all of that. But just know, once you provide your consent, the school has 30 school days to complete it. And also, once you request the evaluation, the school has 10 school days to get your consent. So making sure, mark your calendars. When you submit a request, mark the calendar, count 10 school days out. When you sign your consent, count those 30 school days out to make sure those timelines get followed.
I have a couple things to add to that slide. The first is, I went to a private school. I went to Lake Michigan Catholic Schools, 1st through 12th grade. And I had several classmates and classmate siblings and different people who had different diagnoses, dyslexia, things of that nature. And the school, was not willing to provide them services as a private school because they didn't have to. But after a fight, they allowed them to go, at least for part of the day, at high school at least, to the local public schools, whichever was their district school, to be able to receive services if that's what the parent wanted them to be able to do. And so that is an option if your child is in a public school. In a private school, that if there is a public school that offers certain services that are available to address whatever the particular need is, that you can ask them to be able to do that, and they'll get in contact with the homeschool for it to apply. The other thing in regards to this, you may have heard the word read. That is really what starts the evaluation. It's very simple. You don't have to say a whole lot. There's not a whole lot of legal language that you have to say. You just say, I want to initiate a read. I want to start an evaluation for special education services for my student, and just sign that and date that. There's not a, particular form that they'll kick it back and say it doesn't count if you don't do that, but it needs to be in writing. Last thing I'll say, because I do a lot of foster care cases, if a child is in foster care, but the parental rights have not been terminated, then that parent has the right to be able to initiate a read and also to be able to attend all IEP meetings. Those signatures need to come from the parent, not foster parent or DHHS, unless they have a letter that allows for it. The parent has to be included in that process, and the federal law requires that the parent is notified.
And so you get to the IEP meeting, so the evaluation is done. You are now in an IEP meeting, and they decide that yes, your child is eligible for services. So what do you need to know now? So again, we're going to be developing what's called an IEP, the Individualized Education Program. So it's the detailed description of the instruction and services that your student's going to be provided. And it's going to be customized to that child's individual needs based on that evaluation report, which again is why it's really, really important to make sure that you have a very good quality comprehensive evaluation, so you can really know what exactly are your child's present levels, what are their needs, what are the recommended accommodations and services. And then as part of the IEP team, there's a number of people. You have the child's, at least one of the child's general education teachers, at least one of their special education teachers. You need to have a school district representative, someone who can speak to what resources the district have, what is available to the student. If it's coming after a read, you need to have someone there that can speak to the evaluation results and can answer questions about that evaluation. The parent has to be a member of that IEP team. And then you can invite the student as appropriate, especially once they turn 16 and we're looking at transition services. Also, as they get older, transition services, agency representatives, so possibly someone from Michigan Rehabilitative Services, to again start bridging that time from high school to post high school. How are we making that a smooth transition? And then also part of the IEP team is anyone else that the team wants to invite that's knowledgeable about the child. So if the child is getting services from an occupational therapist, a speech therapist, a physical therapist, a social worker, whether at the school or privately, those people would be great to invite to the IEP team because they can really speak to the child's performance and needs.
Only thing I'll add to this slide is if you are a parent who does not have primary custody of your child, but you have joint legal custody, then you have the right to be able to ask to be a part of the IEP meeting, any IEP 504 meetings as well, if you have joint legal custody. So you need to make sure that the school has your contact information and that they invite you to these meetings as well, and to be able to be a part of the decision-making process. And you have the right to invite these other folks like therapists and things of that nature to be able to be involved, because they have good information for the team at the school, if it's outside of the school, to be able to put something really great into that plan.
And so as the parent or guardian, how do you know when the IEP team is meeting? So the district has to notify the appropriate parties, so the parent, guardian, surrogate, JL, whoever that education decision maker is, of the purpose of the IEP meeting, the time and location of the meeting, and who the other participants are. And they need to give reasonable notice. And the meeting has to be at a time and place that's mutually agreeable. So this is something to be really cautious of. If the school sends you a notice 2 days before the meeting and says, hey, meeting, it's Wednesday, meeting's Friday at noon, make it or not, this is when it is, that's not appropriate. You have the right to say, hey, that time doesn't work for me. I'm available XYZ date and times, because it has to be mutually agreeable, and you as a parent are an equal participant of that IEP meeting. And then the education services that are guaranteed to a child with a disability is FAPE, and I'll go over that. Liz and I will go over that more on another slide. And then, do you need to sign the IEP at the end of the meeting? No, you do not need to sign immediately. You only need to sign your consent for that initial IEP. Michigan does not require parent signature for any annual reviews, but at that initial one, you can take it home. And Liz, correct me if I'm wrong, but you have 7 days to sign your consent, and the school has 15 days to implement their offer of FAPE.
Right. And I think that's also qualified as school days, so it's not business days. So we have to, sometimes, especially if it's being done over the summer, that could become an issue. Other thing I'll add to this is, we're now in the land of Zoom, and I think Zoom for certain things is going to be here to stay. So you may have situations where they're trying to get you on Zoom or Microsoft Teams or Google Hangouts or some other way to meet. So if you have a technology issue, a connection issue, make sure that you highlight that at the beginning so that there can be appropriate accommodations for everybody who wants to participate virtually to be able to do so. And don't be afraid to say, I don't know how to log into Zoom, or my Zoom isn't working, or, things of that nature, or I need a tutorial on how to do this. Because I think that that's probably going to be here to stay. And especially if you're a non-custodial parent who lives out of state, ask them, hey, I can't come in person, but can you make there an opportunity for me to be able to participate virtually?
Okay. And Liz, I'm going to let you take the lead on this slide really quick. I need to go double check on my puppy. I think she's getting into some trouble.
I trust me, I understand. Thankfully, my cat was running around all night long, so she's tired and sleeping. So with FAPE, that's free and appropriate public education, and that's the special services that actually come once you have the IEP. So this is the law that specifically says what's going to be offered once you have an IEP or a 504 plan in place. It has to meet the standards of the state educational agency. So this is the federal law, but it has to deal with MARS, as we talked about before, and making sure that it's offering things that are available for students in the state of Michigan, in the case that what we're dealing with in most of the schools that we're talking about. And it has to include appropriate preschool, elementary school, or secondary school education in the state. This is an important part of this because, as I stated before, these services start at birth. So things like early on or early childhood delay diagnosis that has special classrooms. You need to make sure that if your child has an early childhood diagnosis, that there's a classroom available for them. I know here in my area that became an issue because every school district didn't have an early childhood delay option. And so they were sending students to other school districts. And so if that's the case, then you need to make sure that transportation is available. You need to make sure that opportunities for the parent to be able to be involved if they're having to travel 10, 20, 30 miles to the school that offers that program is available. And if you have enough students who need to be serviced by the particular services that are not available in your school district, then you need to challenge to say, we need to have more paraprofessionals who are able to work one-on-one with students. So we need to have more speech therapists because there's one speech therapist for the entire school district, and that school district isn't, able to serve all the kids who need speech therapy needs. And those state requirements have to be in conformity with the federal IEP requirements. And then the document that gets created by the school district needs to follow both of those guidelines. You're muted, Jacquelyn.
Thanks. All right, so next slide. What is LRE? This is another acronym that gets thrown around a lot. And so LRE stands for Least Restrictive Environment. And what that means is it's this principle of IDEA that kids with disabilities should be included in the general education program as much as possible. The only time they should be moved out of that general education setting is if there is no accommodations or services that could be provided to the student in that general education setting to educate them successfully. And in that case, the IEP team makes the decision to move the child to something more restrictive. And so I put this visual up to show this kind of continuum of alternative placements. So Gen Ed is the absolute, most inclusive. Then we move into Gen Ed with consultation. So maybe you have an occupational therapist or a teacher consultant just meeting with that Gen Ed teacher to give her, tips and suggestions on how she can modify her classroom and curriculum or whatnot to help that student be successful. Gen Ed with part-time assistance, maybe you have someone coming in to provide services in that classroom setting, or you have a parapro with the child in the Gen Ed setting. Part day in special ed, the kiddo is being pulled for a resource room for maybe some extra direct service in math or reading, or some, speech therapy outside of that general ed classroom. They're spending part-time, outside of it. Or maybe they are in a center-based classroom, such as an ASD classroom or an emotional impairment classroom. And then from there, even more restrictive, is there an entire center-based learning program? So maybe you have a school that is specifically for students with specific disabilities. And then the most restrictive is generally homebound placement. The child is staying at home and a teacher comes to educate the child there. And I would say this is something to watch for. I feel like where IEP teams are very, very quick to pull kids out of the classroom before really considering a range of services that can be provided in the classroom.
Yes, if you start hearing them have discussion about self-contained, your ears need to kind of perk up and say, okay, well, what does that mean? Because a lot of times, especially for the older students who would normally be transitioning to other class periods throughout the day, if they do self-contained, they may be in one classroom all day. And in that situation, you want to say, well, is there a situation where they can do some gen ed classes, even if it's, what we sometimes call the specials, so music and gym and different things of that nature. Also, if they're going to a specific special education school, for instance, here there's a school called Lighthouse Academy through the ISD for kids with emotional impairments. That school is required to make it available for them to go to their home district, their home school, to be able to participate in things like sports, band, those extracurricular activities that are appropriate for them. So if your child is in one of those special education designated schools, they should also have the right to be able to participate at their home school for different extracurriculars.
So just be very wary and be very wary of if the school, if you're asking about what can my kiddo participate in some of these actually, extra specials with their gen ed peers, we don't do that. That's not part of the program. Be very cautious of those statements and just politely ask why, and document it, because they should not be making those blanket statements. If your child, your child's entitled to some inclusion. And so if they can handle doing gym or recess or music or art with their gen ed peers, they're entitled to that opportunity for that inclusion. So I would really, just be aware of that. And then like Liz said too, with the extracurriculars and after school stuff, definitely make sure to ask, and also be aware of putting the cart before the horse. Sometimes what I've heard is like, well, we just want to get his behaviors under control first. Well, who's to say that getting him involved in some of these after school things won't help the behaviors, because it gives them an outlet, it gives them something to do. So, be very aware of, them trying to say, well, we need to get this fixed first, and, really try and push the team to be open to giving them those opportunities they're entitled to.
Definitely.
And so here's, related to the LRE, the school district is changing my child's placement and I don't agree. What can I do? You can invoke your stay put rights. And what this means is under IDEA stay put provisions, a special education student is to remain in his or her current educational placement while you and the school complete a dispute resolution process. So if the school's saying, hey, we want to move your student to the self-contained classroom, and you're saying, no, I don't think so, you have the right to either file for due process, you have to formally file the complaint, or you have to file a formal written request for mediation through the state mediation center. And one of those two things starts that dispute process, and the school cannot change that child's placement until you guys finish whatever resolution process you picked. You have to either make it through mediation, or you have to make it through your due process hearing, for a decision to be made on where that child's going to go. But that is your right to say, hey, we're going to keep my child put. We're going to keep them where they are until we work this out.
If you see a disagreement coming, ask them to put it in writing. So even if it's an email, have something to show that, along with your complaint, your formal complaint that you have to file, that this has been discussed previously, because sometimes with the mediation, they require that you've had those discussions beforehand.
All right, and then what are transition services? This is something we've talked about, just mentioned very briefly, but transition services are a part of the IEP that are used to assist students with disabilities to move from school life to adult life. So it's a cooperative effort between the school, the student, the family, and the community agencies. Under the law, you have to start these services at 16, but you can start them earlier if it's appropriate. And this is another area that I would say pay a lot of attention to. Make sure that the transition activities really align with your students' interest, their abilities, and and look at what those transition activities are, and make sure that it's actually helping the student build their skill set to achieve whatever their post-secondary goals are. Because I've seen it where 3 years in a row, the student's going to research driver's training, or 3 years in a row, the student's going to research a college. How many years does it take to research a college? Like, that seems like it's a one and done activity. So really pay attention to those. And also part of this too should be inviting outside agencies. So if the school district isn't wanting to invite someone from, the local community college or the Michigan Rehabilitative Services or somewhere, get it in writing. Like, why are we not inviting them? Like, why can't they contribute? Do we already know what services they offer and what they can do? So really pay attention to these transition services, because the goal of IDEA isn't just to get the kid to graduate, it's to help them be successful as adults as well.
Yes, and if there's programs that may be outside of your district, but that you have the ability to help transport the child to, or different things of that nature, look into those as well. Where I worked during law school was a special education center within the district in DeKalb County, Georgia, that focused on workplace readiness. So we had kids from all across a very large metro Atlanta district, and half the day would be in school, and then the other half of the day we would actually be in jobs. And that was now over 15 years ago that I worked there, and I still keep in contact with a lot of those students, and some of those students still have those same jobs that they had when they started in high school, and they've been able to make good paying jobs. They've moved up to manager positions and things of that nature, all because they were able to be a part of that program when they were in high school. So if there's programs like that within your school district, you definitely want to be aware of them and know if that's the right fit for your child. And if there aren't, but there's a program in a neighboring school district, you want to ask them to see whether or not that may be something that your child can participate in.
And this was touched on briefly too. So my child's having behavior issues. Is the school responsible to help? Yes, behavior issues absolutely can and should be addressed by the IEP if your child's behaviors are interfering with their learning. And that interference might be, maybe they're just getting a bunch of write-ups, or maybe they're being consistently removed from the classroom. Maybe you're getting called to pick up, or maybe they're being suspended or ultimately expelled. Regardless of the severity, behavior issues should be addressed if it's impacting the child's ability to learn consistently. And a functional behavior assessment is really the first step that should be considered. A functional behavior assessment is a way of understanding why and how a student with disabilities is having a difficulty in school. It's to determine what is the function of this behavior. And a lot of times I've seen schools kind of skip this and move right to the behavior intervention plan. And the behavior intervention plan, again, it's how are we going to prevent or replace the child's behaviors? What steps are we going to take? And so ideally the behavior intervention plan should come after an FBA, so we can make sure that the plan is based on data and that we have an effective plan in place. The law doesn't really have any clear requirements on when you should do an FBA or when you should do a BIP or what the qualifications are. Best practices, it would be to have a board certified behavior analyst. But if not, it should be someone that is trained in behavior analysis.
Push for a BIP if you think it's going to help.
Yes.
I'm a huge fan of BIPs, and it can be as simple as, I have some students who, and I love the slide because when you look at the different things listed within the face, there's some things and you're like, what? OCD and hypochondria, arachnophobia. But these are things that can prevent a child from being able to fully access education. So these are important. And so I had a student one time who really had significant OCD and hypochondria issues. And so instead of being out in the hallway with everybody, she was allowed to leave class 5 minutes early, and be able to go to the other class 5 minutes early, so she wasn't out in the hallways and she could use the restroom without, do her like 15-time hand washing and different things. And then of course her therapist was incorporated in the plan to help reduce those behaviors. But there were things within the behavior intervention plan that allowed her to be able to go through some of those issues without feeling overwhelmed in a, super busy hallway and in between classes. In that little 5 minutes, all the teachers knew it, and it wasn't really a huge issue.
I disagree with the school's evaluation. What can I do? If you do disagree with an evaluation done by the school, or if you disagree with the school's decision not to evaluate at all, you do have the right to request an independent educational evaluation. You have the right to one independent evaluation for every evaluation done by the school. So really how I usually define that is if we do a comprehensive reevaluation for eligibility and the school is saying, well, we're only going to, test in specific learning. I say we want a reevaluation that's comprehensive, looking at, ASD, SLD, EI, and OHI, because the child is showing symptoms related to all of this. And then again, it is at public expense. The school will give you a packet of kind of the criteria. They'll say it has to be under this amount of cost. You have to have, make sure the person has these kind of credentials. And other just basic criteria. Make sure you share that criteria with who you think you want to do the independent evaluation. And then if the chosen evaluator isn't able to do it within the cost set by the district and you're not able to find anyone else, you can request the district to increase the cost for unique circumstances, but you'll need to be very clear what your unique circumstances are that justify raising whatever cost the district set.
I would add for my fellow people who may live near the border. So, we're very close here in the Berrien County area to a lot of services in South Bend or Elkhart. And so a lot of times there may be pushback to say, oh, well, that provider is in the state of Indiana. And they'll say, well, there's a similar provider like up in the UP 12 hours away. And you're like, okay, no, that doesn't make sense. We need to be able to use this person who is in South Bend. Push for that it can be allowed, but they're going to try to give you a little pushback on it if it's somebody from Indiana or Illinois or Ohio for folks on the east side of the state. But it has been done, and it can be done because a lot of times those border cities have more resources than some of our smaller cities who are right on the border.
And then we'll go quick. We are getting close on time. But my child didn't qualify for an IEP. What about a 504 plan? So we touched on this a little bit earlier. So 504 is another opportunity for your child to get services. Under 504, a child is considered a student with a disability if they have a physical or mental impairment that substantially limits a major life activity and interferes with the child's ability to learn. A major life activity is learning, reading, thinking, walking, breathing. It's a very exhaustive list, and the list on the, under section 504 is noted as being non-exhaustive. So it's any major life activity. So it's a much broader scope of eligibility. And the main differences between IEP and 504 is the 504 process isn't as involved. It's not as detailed as what you have to include in a 504 plan. A 504 plan is very simple. What are you giving to the student? There's no goals. There's no present levels listed. It's just what are the services. It is 504 does apply to programs that receive federal funds, which is why it does generally apply to private schools if they're receiving, lunch money or any sort of training funds from the federal government. 504 prohibits discrimination, so it also applies to parents. If you're a parent with a disability under 504, the school does also have to be accommodating your disability to make sure you have equal access to participate in meetings and your child's education. And then 504 also directly prohibits retaliation.
I like 504 plans for older kids who are able to say, my plan says that I need to be able to do this, or my plan says I need to be able to do that. If a child is younger and not able to do so, then you're really going to be looking at the parent or guardian to be able to initiate that 504. But that ability to kind of kick it into gear with whoever the teacher or provider is important. That's an important aspect of the 504.
And then just some general stuff. So IEPs, they do get reviewed at least once a year, but you can request an IEP meeting at any time. So it kind of, the review can occur sooner. If your IEP is past due, so say you should have had your annual review on February 4th, it's now February 9th, the school has to be following that old IEP until you have that new review. Students with disabilities should be reevaluated at least once every 3 years. I highly recommend you do not skip these reevaluations. The school will often try to get you to say, oh, no more is needed. But I would argue it always is, because your child, they're growing, they're changing, their needs are changing. And this purpose of these evaluations isn't just to make sure they're still eligible, it's to determine what are their educational needs. So by having those standardized assessments and, clear data, evaluation data every 3 years, that just helps you see, okay, what progress is actually being made, what are their current needs. Can you unilaterally place your child in a special school and expect the district to pay? Generally, no. There's a lot of requirements in requesting a private placement for your child at district expense. So you want to make sure you're giving them clear notice. It has to be within a certain time frame. If you don't, then you kind of lose your ability to be reimbursed, or it can be lessened. So if you do think your child needs a private placement, that's when I would highly encourage you talk to an attorney and make sure that you have all your ducks in a row before making that ask of the school. And quite frankly, in Michigan, because schools hate paying for private stuff, be prepared for an uphill battle. So you want to make sure your best chance is to just be super prepared, but even then prepare for the worst. And then, can your student with disabilities get special education services during the summer? Yes, through extended school year services. In Michigan, we most typically look at whether the child's going to regress over the summer and take a longer time to recoup than their peers. But some other factors that could be considered for determining ESY eligibility is the severity of the disability and the lack of progress toward IEP goals.
Only thing I'll add on that is do the 3-year reeval. It is so important to, especially if the child is in the high school age and they're supposed to be doing that annual planning that Jacquelyn talked about earlier with the specific life goals, like the 3 years of looking into that, if that's a freshman goal, then that needs to be completed by freshman year. And then they're going to be reevaluated again, end of junior year, beginning of senior year. Really important to have that reevaluation before they end up finishing up and graduating.
And then just suspensions, disciplinary rights. So for short-term suspensions, 10 days or less, informal hearing. It's really as informal of, hey, teacher said you hit Susie in the back of the head, child saying, oh no, that never happened. Principal saying, well, I don't believe you, you're suspended for 2 days. That counts for an informal when it's less than 10. For anything longer, you do need more formal proceedings. I'm not going to go through this in detail because we are running short on time, but just know there are more procedures that need to be followed. You do have a right to a hearing. If they're recommending expulsion, you have the right to present witnesses, cross-examine witnesses, see what the evidence the school has, and you have the right to be represented at expulsion hearings. And the school also should be considering 7 factors to determine, is expulsion really the appropriate avenue here, or would lesser interventions or restorative practices be appropriate?
Any specific questions on this, let us know. But the biggest thing is a text message from the school principal does not count as the proper notification for 10 days of expulsion. They need to give you a formal letter that gives you all of your rights, including that right to have a hearing and to have representation at that hearing. Do not let them send you an email or send you a text message. I see that literally once a week, and that's not the proper way to do it when a student has an IEP or a 504 plan.
And when the child has an IEP, they have some additional protections as well. If the school is recommending for a suspension for anything more than 10 days or 9 days, really, if it's 10 days or more, then you have to have a manifestation determination review to say, okay, was the behavior a manifestation of the child's disability? Was it related to it or substantially related to it, or was it a result of the school's failure to implement the IEP? And if it is found to be a manifestation, then the school is not able to expel your child or suspend them for more than 10 days. And then also too, regardless of whether the removals are consecutive or just kind of spaced out, once a child with a disability or with an IEP has been out of school for 10 days, beginning day 11, the school has to be providing some services. If it's another short-term suspension, it can be as simple as maybe the teacher sends the work home, or maybe the kiddo gets some extra time to make it up when they get back. But they need to be getting some educational services when they're out beginning day 11. And that's something that schools miss a lot.
Yes, and it's not just a packet of the same stuff over and over again. I have a lot of children who are in hospital placements or in residential placements. They need to be providing tutors. They need to be providing meaningful educational opportunities for that child.
Especially for like the long, if they do, for whatever reason, before with the long-term suspension or expulsion, the services provided have to be decided by the IEP team, and it still has to be reasonable to allow the child to make progress. So the school, a lot of times what they'll say when kiddos are expelled is, oh, we'll send a teacher like home like 2 days a week for like an hour a day or 2 hours a day maybe. And I'm like, how is that reasonably calculated? The kiddo has 5 IEP goals and he's 3 grades behind in reading and math. Like how is that helping him? So definitely just something to be aware of and notice. So it's just, again, that MGR, making sure that it's taking place if your child has an IEP. And again, if it's found to be a manifestation, they can't move forward with expulsion. If it's not a manifestation, they do get to move forward. And then regardless of the outcome of the MDR, the school generally can't unilaterally just change a child's placement. However, they can request the IEP team, and as an IEP team, they can say, hey, the consensus is that the child should be moved to a more restrictive placement. And then in that case, it goes back to those state put rights we discussed earlier, that you can say, hey, no, the child shouldn't be moved. You should be increasing your services here. But just be aware that there are some collateral consequences to disciplinary actions that require some additional meetings and brainstorming. And I'll just skip ahead. So real quick, we'll talk about some other areas where education issues pop up. So namely family law, delinquency, and child protection. So abuse and neglect cases. Looking at family law, kids can develop mental health issues. Then those mental health issues can then have a direct impact on their ability to access school. They also, I've seen, and it's really, really unfortunate, but I have seen in some custody cases where the parents use the child's academic struggles as a weapon against the other parent to be like, oh, well, so-and-so isn't doing their job because my child's struggling. So just being aware of that, making sure that, if your child's struggling in school, that's just what it is, and work together to make sure that the school's providing the right supports and that you as the parents are working together for the child. Delinquency, again, if the child's having any kind of criminal behavior, it's probably not whether they're a criminal. It's in fact, they might have an untreated or undiagnosed mental health issue that's causing them to act out in this way. And they just need to have better supports in school and also possibly in the community. And also just making sure that their probation terms, taking into account any mental health issues. If they have super anxiety and they suffer from school avoidance and their probation says, well, they have to go to school every day and follow all school rules, that's potentially setting them up for a probation violation. And it's not through any fault of their own. And then child protection cases, kids in foster care may have to change schools sometimes. So really trying to make sure that happens as little as possible. That children, maybe facing trauma. So that could also manifest in some behaviors or learning at school.
Again, if there's any additional questions on this, please let us know. Also with delinquency, if you have a child who for some reason is taken out of the school and put into a probation placement, a delinquency placement, a residential placement, they obviously still have the right to continue to get their education. some of those placements provide education on their own, but then in certain situations, it's still going to be run through the school district where they're enrolled. So those are things that really need to be addressed. And, don't let the school, file charges or send charges to the prosecutor's office and then say, oh, we don't have anything to do with it anymore. They need to be working in tandem with the probation officers and the courts and the students' parents and the students' defense counsel and everyone else to come up with a plan that's going to be the best way to rehabilitate the student. Because if they're in delinquency court, the goal is rehabilitation.
And questions to ask parents, if you are an attorney working with, delinquency, abuse, neglect, or family law, just asking the parents, hey, how are your child's grades? Do they have any of these diagnoses? Do you have trouble getting them to school? Is your child doing a lot of missing assignments? Do you have to pick them up from school? How frequently? Disciplinary issues? Have you had any conversations with teachers about concerns? And just really some of these questions just to kind of gauge, like, is there an underlying education issue that needs to be addressed, that's impacting what's going on.
And please let your delinquency defense attorney know if your child is on an IEP and give them a copy of it. Please, please, please.
Yes, do. And if the delinquency attorney, and unfortunately I've seen this a little bit too, where a delinquency attorney doesn't care, make them care. You tell them my child has a mental health impairment, like that's what's causing this. Make that delinquency attorney care.
Absolutely.
And so some comments to look for is if you hear comments like, oh, my child's failing, my child struggles with reading and always has, or whatever other subject, or, oh, my child has ADHD, they never listen. My child just got expelled for choking a kid in the bathroom, and, that just seems like, that's out of character for them, or, they have this aggression and I can't get them to, help it. My child struggles to make friends. So just look for these comments that indicate some sort of underlying mental or physical impairment that needs to get addressed through some sort of treatment in school programming. And so we'll just give some quick examples in the next 3 minutes, then we'll have 5 minutes for questioning. So example 1, you have runaway Ricky. So Ricky is in 7th grade. He's charged with assault and battery against a teacher. Ricky is diagnosed with severe autism, along with some other mental health diagnoses. He's been on an IEP since he was 3. He was mostly mainstreamed in general education classes at his last school, but since moving to his new town a year ago, he's been in a self-contained classroom with the intermediate school district. In that self-contained classroom, he has trouble following policies. Mom gets calls regularly that Ricky's been physically and verbally aggressive, or that Ricky has run away from the classroom. The school hasn't tried updating Ricky's IEP. They also haven't done any new evaluations. They haven't done a behavior assessment to try to determine what Ricky's, needs and behaviors are. And most recently, Ricky ran out of the school building. Multiple staff chased in. They cornered him with giant gym mats in a corner of the fenced-in recess area. Ricky told them not to come any closer or he would do something bad. And when they continued to approach, he threw a rock and struck a teacher in the forehead, cutting his skin. So what can you do in this situation is, we would recommend, reach out to an educational attorney if education law isn't your area of practice. The education attorney can then assist with requesting a reevaluation from the school, doing a comprehensive records request to really see how long some of this stuff has been going on, what has the school done or not done in response, and they can assist the parent if appropriate based on the documentation, and filing a due process complaint against the school for their actions and inactions. You can also, in the delinquency side of things, file a competency evaluation with the court. Is the child competent? Is he criminally responsible? Request an adjournment of the juvenile proceedings to allow you time to collect and review the education records as necessary for your client's defense. And then you can also consider filing a motion to dismiss, arguing that this is a school matter, not a symptom of criminal behavior, and it's in the interest of justice to dismiss the charge and allow the school the opportunity to increase the student's behavior supports.
Everybody has to work together in a situation like this. That educational attorney should be, if you have a defense attorney who's not versed in education law, should be working hand in hand. Once they get that IEP and that documentation, it should be provided to the defense attorney to file the competency evaluation with the court. Then whatever the court issues needs to be provided to the educational attorney to provide for the state complaints and things of that nature. So everybody really needs to work in tandem in that situation.
Example 2, slow reader Sally. So you have Sally's parents fighting over who gets custody of her. Sally's in 1st grade, but has struggled with reading since kindergarten. And her last report card said she was behind in all areas of her reading benchmarks. The school hasn't evaluated Sally for any reading disabilities. And when dad asked, the school just said, oh, she's still young. We should wait another year. And a lot of students were struggling because of COVID. But then they turned around and said they thought Sally should repeat 1st grade for more practice. Mom's now pointing out Sally's bad reading grades to say dad's not paying enough attention to her schooling and that he should lose custody because of it. And now Sally's also starting to have some behavior issues in class, and she's refusing to complete assignments, and she's fucking, out of turn. What can you do? Again, education attorneys can help here. They can request the evaluation from school, make sure it's comprehensive for both the reading disability and now the new behaviors that are being shown. They can make sure that there's, again, get the records to see what supports have been provided, and they can assist the parent in reviewing the evaluation report and making sure Sally gets an appropriate IEP, and if necessary, making sure the school can't keep saying, oh, we'll just wait. And then representing dad in the family court, really emphasize what he's taking to improve the reading performance and classroom behavior for his involvement. And, and honestly, sometimes too, as it's appropriate, depending on the relationship between the parties and the attorney, maybe talking to the other side's attorney to say, hey, how do we come to a resolution that keeps both parents equally involved?
I want to add anything on that because I do see on Facebook that there's a couple of questions. So I think we should definitely get to the questions that are here.
Okay, perfect.
Sure.
Perfect timing.
Sure. Let's see. Yes, from Lisa. What is the best way to go about getting educational records? I have made requests pursuant to FERPA in the past, and they have either come back incomplete or taken a very long time to get.
So the first thing that I'll say on that is that your request should be really through FOIA and do a formal FOIA request. Each school district and each school should have a FOIA coordinator. That's Freedom of Information Act request. What they're going to use to try to not release information to you is FERPA. So for instance, if there's a bus video and there's a bunch of kids on the bus and you're looking particularly for what one student did, they'll say, oh, I can't give you that information because I can't show you the other students who were on the bus. I've, as an attorney, have been able to say, well, this is for this purpose. I need to be able to at least view the video at the school. Even if I don't get a copy of it, I need to be able to view it. So there's different things you can do to at least be able to get access to information that they're going to say may not be accessible because of FERPA. But if you do a FOIA request, it's the same as any other FOIA request to a government agency. They have a certain time frame, 10 days usually, to be able to get you the information or ask for an extension, and they have to put that in writing what they're extending. They may try to charge you for all the paperwork and copying. They can charge in certain situations, but if you get a bill for like $500 to get records, you need to contact an attorney to negotiate in regards to what some of those documents may be free. But if you do a FOIA request, they have to respond to you to either ask for an extension or to give you the information within 10 days.
And I'm a little bit different in how I do it. I do request under FERPA. And I know in my calendar, it is a 45-day timeline the school has to respond to give the parent the right to review and request. Generally, I'll have the parent request. I have a sample form that I have parents just sign and date, and I fill in the top. They'll submit it to the school in writing. I ask the school to confirm receipt, and I have the parent follow up every 2 weeks, being like, hey, I sent this on this date. Where are my records? Where are my records? Always being very polite, saying, hey, I understand you had this many days, but I'm just wondering if you can give me an update. And if the school is really responsive at the get-go, then I generally don't follow the 2-week timeline. I give them the opportunity to comply with their initial date. But if I don't get the confirmation of receipt, then I'm following up very consistently, just to keep on them politely but firmly. And then potentially, I haven't had to yet, but if I were to need to, I would look at filing a complaint just for lack of compliance, or at least putting in an email of hey, you have to respond by this day, or I have the grounds to file a complaint.
Yeah. And I think for a lot of education-based, solely education issues, that makes a lot of sense. Mm-hmm. If it's a delinquency charge or some other criminal thing that, arraignment's coming up and things, I would do the FOIA And then you can also, obviously, if there's a case going on, have some subpoena power through the court in order to get records as well. But, you know, a FERPA request to get basic education information is not necessarily an inappropriate way to address it. And I think they still do have to provide you written notice if they want an extension or if they're not providing something to you, right, under FERPA.
I believe so. And that's why usually, but I will say too that incomplete records is something that I come across fairly often as well. So my standard practice is once I get the records, I put everything into a chronological timeline so I can see fairly easily where there's some gaps. I'll go through it with the parent. So, you know, does it look like everything's here? And if we can identify something's missing, or at least enough that there's definitely things missing, I'll follow up with the school and say, hey, we think XYZ is missing, or hey, we feel like something's missing. Can you confirm this is all the records? And can you confirm nothing else exists? And it's amazing, by using those words, can you confirm nothing else exists? More records magically seem to appear.
Okay. And let's see, Homer asks, does the school, college, universities have responsibilities to disclose that they operate under these education laws?
Well, that's an interesting question because we know they do. You know, if they get any type of public funding at all, then all of the different things that we've been requesting do apply to them. Now, if you do have that parochial school or private school in certain situations, then they may not fall under all of the rules, but several of them, like Title IX and things of that nature, is going to apply to them. So, you know, if you're making a request and they say they're denying it, or they're saying that rule doesn't apply to us, that's going to be a problem, because it's going to be a very rare situation where at least one of the different either Michigan Education Act or federal law isn't going to apply to them at some point.
Okay. And let's see, as far as the tribe's education program, if a college student has a known disability and has disclosed it to the education department, are they held to the same standards as normal students?
So I saw an earlier question too about IEPs following into adulthood. So I'll kind of I'll address both of these. So really, when you get to the college level, your primary source is going to be the ADA. If you remember Jacquelyn giving information about the Americans with Disabilities Act, that's where you can ask for specific accommodations in, you know, college courses or technical school courses and things of that nature. If they receive public funding, then they're going to have to follow those guidelines as well. So while they don't necessarily have to take the IEP from 12th grade and follow it in college, if you provide it for them to show what previously has been provided, to say this is why I need an ADA accommodation, then they are required to do that. And I've seen that in the college aspect for many different things, such as, you know, extra time on tests and seating accommodations and, you know, different placement accommodations and additional resources available through the school that you don't have to pay for and different things of that nature. So even though they don't have to follow an IEP plan, they do have to follow the ADA and provide reasonable accommodations if you need those.
Okay.
And I believe, doesn't Section 504 also apply to colleges as well?
It does. It's more limited, like they'll go to ADA first, but then there's also 504 protections as well.
Okay, and Homer also says, sorry, I didn't finish. Should they be penalized for not maintaining high grades, etc.? What should they have in place to help these students rather than penalize them and make them pay back funds?
There's a lot of different things that are into that question. You know, obviously, you know, you have situations where students are accepted provisionally in different schools. So a lot of the local community colleges will say, you know, we'll accept you, but you have to take these certain courses and get a certain grade in them in order to continue going forward. If that's a situation, then they really should be having ADA accommodations. Now, that doesn't mean that it's going to force a teacher to change a failing grade if they're not completing the work, but it will make them look back to say, did we provide all the accommodations necessary? And maybe instead of giving this as a failing grade, we need to do it as an incomplete and give them an opportunity to finish up during the summer semester or during the break or something else to be able to raise that score. So if the accommodation has been allowed and they don't follow it, then there can be penalization against the school. But if you never make the request for the accommodation, then it's going to be difficult to prove that.
Okay. Let's see. What about the tribe's part in this?
Well, I know that the Pokagon band, which is the one here local to me that I deal with most often, has so many additional resources and services available to young people throughout their time. I know there's also some school programs too. They provide tutoring, they do things of that nature. So for instance, at an IEP meeting, if a child is a member of the Pokagon band and they're receiving services from the Pokagon band, then I would want somebody from the Pokagon band at the table during the IEP meeting. Even if that's with a different school district, they should be a part of the planning and be a decision maker and in that role. And we've had them. We have. I see Tori's on here, and she gave a shout out. She's a social worker with the Pokagon band, and she's often at IEP meetings and helping to get additional resources. So I think that social work departments at the tribes can have a huge impact on making sure that these services get provided for all of the students.
Okay. And let's see. Can my fully virtual student be forced to come in person for exams?
This is going to be fun, isn't it, Jacquelyn? As we kind of go back to this this post-pandemic world and what's
Yes.
going to be a part of IEPs. If the student is totally virtual for health reasons and that is documented in a 504 plan or an IEP, I would say that you definitely have some ability to say that they should not have to come in person and make accommodations for that in one way or another to get the exam done appropriately. But that's probably something that's going to end up being litigated in one way or another in the next couple of years as we exit out of the pandemic.
Okay.
Yeah, I would agree. The pandemic and virtual learning has been very interesting. And
Yes. Let's see. And can a college program change the passing percentage requirement from 75% to 78% while I am mid-program?
I'd need to know more personally in order to discuss that. I remember particularly when I was in school for all the different programs I was in, we would get a specific manual at the beginning of each school year. And, it's kind of like you pay your tuition, you agree to this manual for the school year. But then I know in certain programs, like nursing programs and different things of that nature, you've got the same manual the whole way that you go through. And if something changes, it takes a lot to change the requirements. So that person can reach out to us with specific questions, but it really kind of depends on the program.
Okay. Let's see. And as an 18-year-old in Michigan, can my high school force me to retake my SAT because everyone did poorly?
The SAT, no. The SAT is an aptitude test that it to be quite honest is voluntary, except if you're applying for a school that requires it for one reason or another. I don't know if maybe that's the PSAT, but the PSAT is just, the essentially precursor to the SAT to kind of gather information on you. There shouldn't be anything connected to like your grades or ability to graduate for taking the PSAT or SAT.
Okay. And then Homer once again says, what if your tribe is not taking disabilities into account when making their rules regarding education funding and expectations?
So I guess I would want to know from Homer, is this a tribal school or is this some other type of funding, like a per cap that is tied to getting a certain grade or something of that nature? I would need to know a little bit more information. And I think that's probably going to be very dependent on, what the council for the tribe puts into their requirements as well. If it's a tribal school and they're not taking into account disabilities, they're going to be under all of the laws that we've talked about, and they need to take account into that if a student's on an IEP or a 504 plan. If it's something tied into like a per cap and they're not taking that, that's probably going to be something that's going to specifically need to go to the council.
Okay. Yes, he came back. He said it's the college student funding.
Okay. So that something tied into the specific payments from the tribe, that's probably going to be a question for the council.
Yeah, funding coming from the tribe. Yes.
So you may
Oh.
want to, if there's a website for that particular tribe that outlines all the rules, and they want to send that over for me to review or something of that nature, I can look at that, but that's going to be something council specific.
Yes, exactly.
Mhm.
Okay. Well, that's all the questions we have today.
Well, thank you guys.
Yes. Well, thank you again for that very engaged and highly informative discussion. We will post your contact information. And please send me your slides. We'll post them to the Mills website. You're both highly educated in this area of law, and we again greatly appreciate your participation today. Thank you, Miigwech.
Thank you.